Our next defence is the defence of qualified privilege. So what is qualified privilege? It's related to absolute privilege in that both of them arise from the idea that there is a public interest in the communication of certain types of information. Absolute privilege, that I deal with in another video, says that there are certain places and proceedings where freedom of speech is so important that it must not be abridged by defamation, that gives an absolute privilege to say what you wish, no matter your motive and no matter the content. So that is in relation to the law of defamation at least. So for those, look at absolute privilege. Qualified privilege, on the other hand, is other forms of speech important to the public, but it has limits on it or qualifications. This qualified privilege arises both at common law and under the Defamation Act. At common law, it's often called public interest communication and might also be referred to as political or government communications. Under the Defamation Act, have a look at section 30, and it gives a defence of qualified privilege for the provision of certain information. At common law, there was a reciprocal duty required. So the public must have had an interest or duty to receive information, and at the same time, the person who made the communication, which includes the alleged defamatory matter, must have had an interest or duty, whether legal, social or moral, to make that communication to the person to whom it is made. And that was first what was set out in the case of Adam and Ward. Public interest communication means that a defendant will be able to argue that the matter published that is defamatory is protected where the information is on a subject of legitimate public interest and is of such a nature that for the convenience and benefit of society, there is a duty to the publisher to publish it. That means that information must be released, or there's a moral, social or legal duty to release the information, even if it may be defamatory. And there must be a duty to receive or an interest in receiving that information on the part of the person to whom that is communicated. That person might be a very small group of people, for example, giving information to the police or to others, or it might be a very broad group of people, such as publishing something in a paper or on the ABC. The common law defence is defeated by malice. So if you think something is important and that you have a duty to communicate it, then you have a defence. But if you think something, if you have an improper motive to actually communicate that information, the court would say you haven't been just complying with a duty to do your social duty or your legal or moral duty. You're actually doing something improper to, for example, strongly benefit yourself despite knowing you're lying, or to maliciously attack someone. So in those circumstances, if there is malice, then this defence will not hold up and the defendant will not succeed in their defence. So an example of this is the case of Roberts and Bass. What happened in this case was that a politician was running for Parliament, was running an election. His opposition, Roberts, and another man, Case, who were running directly against him in his electorate and an associated electorate, created some how to vote cards and some postcard type advertising that they put in people's mailboxes. Those items look like a frequent flyer list, talking about, and they were trying to create the impression that Bass was perhaps improperly using public funds to fly and to go to a range of places. So what were the defamatory imputations in these mocked up cards? The plaintiff argued that the imputations were that Bass misused public money for his own personal benefit to the detriment of his constituents, that he took advantage of his position as a parliamentarian to obtain a free holiday to certain destinations, including Nauru, that he was receiving frequent flyer points for the benefit of himself and his family, and the main issue when it went on appeal was whether Roberts and Case were published the matter with malice. So did they create this frequent flyer communication out of a duty to inform the public who would have an interest in knowing about a politician who was running for Parliament, or was it done as a matter of malice? If it was malice, then they can't use the defence of qualified privilege. The court considered, when is it malice? And they said malice will be established where the statement is predominantly motivated by an improper purpose. That is, a purpose that is foreign to the duty or interest that protects the making of the statement. The ill will needs to be the prominent motivation. So you can hate someone but still have a duty to communicate about them to the public. On the other hand, if you have no perception that you have a duty, or no reasonable perception that you have a duty to communicate to the public, then that won't be your prominent motivation, and the ill will may in fact be the prominent motivation, in which case you couldn't use the defence of qualified privilege. They looked at what does it mean if you know something is a lie, because the fake frequent flyer account that was featured on these advertising materials was a lie. It was completely made up. They had no reason to believe it was true. And they said knowledge of the falsity by itself is not an independent basis for malice. Just simply knowing something is a lie. Motive is key. However, when you can prove that someone knew something was a lie and still communicated it, that's almost invariably proof of improper motive, because you wouldn't believe you had a duty to communicate an important matter to the public and simultaneously feed the public a lie about that topic. So the two things being inconsistent, that tends to be very, very strong proof of improper motive and very strong proof of malice. So they then went through a range of different things that are important in helping the court or a jury to figure out if there has been malice. They said that in addition, sheer recklessness about truth is enough to justify a finding of malice. So in some exceptional cases. That is, not knowing positively that it's untrue, but being completely reckless and having another improper motive may help to justify a finding of malice. However, mere lack of belief in truth is not the same as knowledge of falsity. It's quite different to know you are telling a lie and to not be sure if something is true. And then you look at other circumstances to try and figure out what the defendant was thinking, whether it was malice. So if the defendant presumed something was true and didn't turn their mind to the question of truth, then that's not malice, even if it is a lie. You can't use the defence of truth, but it may be a matter of qualified privilege if they thought that the information was something that they had a duty to communicate to the recipient. Mere carelessness doesn't amount to malice, and failure to apologise is not evidence of malice. They had a further look at what is malice in the case of Wilson and Bauer Media. That's Rebel Wilson's case. Because Bauer Media used qualified privilege to try and argue that they had a duty to communicate information to the public, and the public had an interest in receiving that information. And the judge in that case said, for reasons that later appear, I've concluded consistently with the jury's finding. The jury found the judge was making a decision in relation to common law malice, and the jury had made a decision in relation to statutory malice. There were reasons why some was left to the jury and some straight only to the judge. And found that the way the case was put to it, that Bauer Media's subjective intent or purpose in publishing the articles he found was unreasonable. They ran a campaign against Rebel Wilson that was calculated by Bauer Media to generate commercial benefit for it. It knew the imputations were false, and it understood the probability of rapid and massive spread over the internet. And it kept the story going after Ms. Wilson had tweeted a response which showed that she was unhappy with it and that she was implying that the original report was untrue. And those inferences were open to the jury, and they were not, in fact, refuted by Bauer Media. They also looked at who has the duty to bring evidence in relation to this defence, because remember, I said that for a defence, it is up to the defendant to prove the facts which are the basis of their defence. And the court went on, because there was no evidence from senior members of the Bauer Media companies or group, they found that there was no evidence of the state of mind of the persons in control of or directing the publication of the article that identified Bauer Media's state of mind. Without that evidence, the court could not be satisfied that Bauer Media in fact genuinely believed on reasonable grounds that they had a duty to communicate this information to the public. And they said Bauer Media needed to prove its state of mind and the state of mind of its relevant actors, most closely connected with the decision to publish each article. Not only the decision of why to write the article or the content of the article on the part of the journalists who gave evidence, but in addition, the editors and those above them who are making decisions to publish and then to continue to push the story after initial publication and to seek for people within the group to continue to write stories. Those people's state of mind was not evident, and therefore the court held that Bauer Media had not proved as a defendant that it had that state of mind that it must communicate to the public. So remember that for common law, you have a duty of reciprocity, that the defendant believes they have a duty, moral, social or legal, to communicate information to the public, and that the public have a duty to hear or an interest in hearing it. For the statute law, remember that the test is, does the defendant have a reasonable belief that the public has an interest in hearing the information? Not an interest in the sense of, oh, I'm interested in that, but an interest in the public policy sense. Does it increase public social welfare? Does it increase the proper running of society for people to hear this information? And merely hearing the gossip about a celebrity and that she was allegedly a liar was not something which the public was considered to have an interest in and which Bauer Media would have a duty to communicate to them. So that's qualified privilege. Under the legislation, we look at whether there is that defence of qualified privilege for certain information. And so, as I said, the test here is, does the recipient have an interest or apparent interest in having the information? Is the matter published to the recipient in the course of giving the information on the matter to the recipient? And is the conduct of the defendant reasonable in the circumstances? So was it reasonable, for example, for Bauer Media to think that the recipient had an interest and to communicate material which is not true about Rebel Wilson, for example, when the judge was discussing briefly what the jury must have reasoned? So what is the apparent interest? The defendant must believe that the recipient has an apparent interest in the information, and they must show that they believe that on reasonable grounds. In determining whether the publishing of that information was reasonable in the circumstances, the court can take into account a list of factors that are set out at section 30, subsection 3, paragraphs I to J. Have a look through those and you'll see that they're weighing up a range of different matters. Then, once again, the legislation says that for the avoidance of doubt, a defence of qualified privilege under subsection 1 is defeated if the plaintiff proves that the publication of the defamatory matter was actuated by malice. And if you remember, when one of the defences under the Act could be vitiated by malice, you go back and you look at the common law meaning of malice. So in those circumstances, if the defendant believes on reasonable grounds that the recipient has an interest and is not actuated by malice, then that may be a matter that can be taken into account. But if there is malice, you look at the common law meaning of that, and then the statutory defence will not apply. In addition, the sections make it clear that a defence of qualified privilege is not defeated merely because the defamatory matter was published for reward. This is making it clear that a profit motive by itself is not evidence, is not malice which will defeat the claim of qualified privilege or the defence of qualified privilege. But having said that, if there is an awareness of a lie, if there is a deliberate plan to make profit out of that lie, there's a possibility that there could be malice, and that is what happened in the Wilson case. Bauer Media had this original information communicated to it by an anonymous source many months before the release of Pitch Perfect 2, which was one of Rebel Wilson's largest movies. When Pitch Perfect 2 was released in Australia and was doing extremely well, then Bauer Media made the decision to publish information in its magazines and online, and also knowing that this movie would become available overseas and that it could be its internet material, Bauer Media's internet articles about Wilson, would be accessed around the world. So it made a deliberate decision to piggyback on the release of the movie. It made a deliberate decision to use material which it either knew or ought to have known were lies. And it also didn't check initially whether things were true, and then later continued to publish even knowing they may be untrue. In addition, it did so deliberately for profit, and knowing that there was a very strong risk that this would cause harm to Wilson. They said in those circumstances, it's not just a profit motive, it was a deliberate plan to use lies about the plaintiff to create interest in its products, its magazines and its online sites, to create greater profit for that Bauer Media Group. So in those circumstances, that was found to be a matter of malice. It wasn't just we publish it, it will make us money. It was we know or ought to know it's untrue. We're going to publish it anyway because it's a great time to get this out there and sell a lot of magazines and get a lot of clicks. We're going to keep publishing articles even once we're aware that the plaintiff is unhappy and apparently that these are lies. And they were continuously unrepentant about this chain of action. So in those cases, it was easier to prove malice. There was also, for the plaintiff to suggest malice, there was also nothing on the part of the defendant to show reasonable grounds for believing the recipients had an interest or that reciprocal duty at common law, because they failed to bring the evidence about it. So that's qualified privilege under common law and under statute.